IBM-TV, International Broadcast Media. This is the Lawyer's Den. This unique.
You gotta like the Lawyer's Den.
That's right. This unique broadcast brings you in-depth discussions with leading legal scholars to discuss the pressing issues confronting our nation. I am Bill Tresvant, and along with my esteemed co-host, the Southern gentleman from North Carolina, Nick Palavita, we are your hosts. Nick.
Yeah, Bill, what's up? What?
Okay. How are you?
I thought you said I was muted. No, I'm doing great. You know, we got some good things to discuss today. We're going to bring up Chevron, the antitrust suit, and some other exciting topics, as you well know. But before we do that, should we bring in some of our guests or our panelists?
I think we should.
Okay, hailing from the Salt Lake City area with a JD LLM, who's a practitioner for many, many years, licensed before the United States Supreme Court, and has sent briefs before the United States Supreme Court. I'd like to introduce our colleague from Salt Lake, Jeff Teichert.
All right, in one corner, now in the other corner, Nick?
Well, we have another person in the other corner, hailing from Midgeville, Georgia, who teaches law at Georgia, and he is a professor, another JDLLM professor, not to remind Bill that again, and we have Adam Lamparello. Adam,
how are you guys
welcome
doing?
to the show.
Great to be here.
And then, of course, with our regular host, JD, Bill Tresvant. Okay, he's here too. Who actually heads up American politics on the IBM-TV network, which is seen Sunday at 7 o'clock. He got slotted there. Plus, he also does White House reports every day, believe it or not. So the guy is what do they call it when you work a lot and whatever, workaholic or something like that. But anyway, he has some topics for today. So, Bill, what are we going to discuss today? What?
We do. Actually, it's amazing. I mean, I would have thought that we would have had enough in 2020. But these generational changes, I mean, a president possibly refusing to relinquish the White House, an election in terror, the Supreme Court nominee, fringes of the law frayed, and now we have the biggest antitrust case in a generation. Now, in my lifetime, there have only been three. There was the first one, which we called Ma Bell. For those of you who weren't old enough,
I remember that one.
Ma Bell was, the AT&T, American Telephone and Telegraph Company.
Right.
It operated in every single state. Now, the government came along back in the 80s and filed an antitrust suit and broke Ma Bell up. And Ma Bell turned into Baby Bell. So that was AT&T of New York, AT&T of North Carolina, AT&T of California. It was then turned into what we know today, AT&T, Verizon, and all the other things. Now, today, then the second time was with Microsoft. And you don't see Microsoft anywhere around as they're bundling because the government did the same job to them. And now they've turned their sights on Google. Now, who could challenge Google, Nick?
I don't know, but apparently you missed one. But maybe this is before your time, but it hit my time, Bill. The antitrust suit against IBM.
Oh, I forgot that.
Oh, yeah, that was a big one. Yeah, and so the thing is, these trust busters that are coming down the pike aren't unusual. I mean, well, they are unusual in the fact that one problem that we have today is some of these companies' valuation $2 trillion, not billion, $1 trillion. But I think it's really great because it gives antitrust lawyers something to do. And I remember taking antitrust in law school, and I was going, "What am I going to use this for? If there's no antitrust." So the thing is, now we got antitrust. Yeah.
Actually, Nick, I mean, if they were going to specialize, I mean, because they're going to have to dust off a lot of old antitrust lawyers for this.
Sure. Right.
This is at least a decade.
Yeah, they're going to be taking them out of the nursing homes and sticking them in the courtroom. I mean, that's just basically what you're going to see right now. Hey, I remember the AT&T antitrust.
It'll be like, hey, Joe, remember in 27 when we pulled that maneuver?
That was 40 years ago. 40 years ago, maybe, but I'm getting out of the nursing home to do an antitrust suit. Why are you doing it? Because now the young whippersnappers ever faced one before. Go on.
Okay, well,
if you ever read the IBM, I actually grew up with that case. They were meticulous defending that suit, Bill. I mean, they went through every little detail, et cetera, and they were millions and millions of dollars to defend it, And so the thing is, what happens, it generates tons of legal fees. Adam is looking to leave becoming a professor and start becoming an antitrust expert.
Well,
overnight.
Good idea.
Nick, it just seems to me that the cases begin with, the gentle souls that are merely JDs. They then transfer over to you, who, captures them. And then actually Jeff and Adam write the briefs and then,
JDs do okay. JD stands for just dollars. Okay. It's just like MD stands for more dollars. Okay. So the thing is, they do okay. I'm not sure if LLM adds anything to and that's one reason a lot of people graduate, Bill, and they immediately get a job because they know that with the JD, they just get dollars. Where LLM, what the heck is that for? So it's kind of a, worthless. Something that certain people do. Adam knows he did it. He went to New York University.
Now, Nick, it seems to me, because we're going to go to, Adam and Jeff right now, but it seems to me that we're in a bit of a quandary because we have originalists thinking about these issues that are going to end up before the Supreme Court. And my big question is, I think it was Benjamin Franklin that used an abacus rather than a computer. Now, now I don't know if an abacus is even in the Constitution, so I'm really curious about how any Supreme Court with an originalist theory, either liberal or conservative, Jeff, can possibly untangle technology. Although it does begin with the alphabet, as an alphabet company owner of Google. Adam, how are you going to figure out, when there's no abacus in the Constitution, this antitrust issue?
Well, I think it's a very complex and a very, very difficult issue. I think it's going to be in litigation for years. And I think that I'm not an antitrust expert, but one thing I will say with regard to technology is the Supreme Court is certainly not well versed in technology. And many courts are not. So explaining that in simple and easy to understand terms is going to be very important. I guess part of the issue in the Google case is that they have contracted with other companies to essentially ward off any competition. When you buy a cell phone like mine, like my Android, you immediately get Google. And the question is, does that form a monopoly, and does that, make it difficult for competitors to fairly compete? I'm not sure of the answer on that. And what I will say is this: I don't know what the court's standard is going to be to determine that, and if it's going to be a workable standard. And quite frankly, I really love Google too, and I think all the other search engines are pretty bad. So I don't know if the average consumer is really going to be that interested in this, or is that affected by this. I really don't.
Okay, I'm going to reserve because I do have an answer for that, but I think right now it's Jeff from the other corner. A conservative originalist and an abacus. How are you going to make the Constitution work for Google?
Well, let me come around. I do want to talk about the historical element of this and the founding generation, although I don't know that this is an explicitly constitutional case. I think you're going to be dealing with interpretations of the Sherman Antitrust Act. And the act, as I understand it, requires two things. It requires monopoly power and anti-competitive conduct. Just having monopoly power isn't enough to bust you up. If you're predatory pricing or something like that, which means, if you're pricing something at a level that you're losing money, but you're doing it to kill your competition and then jack the prices up later, that would be predatory pricing. There's, the things that Adam mentioned regarding exclusionary contracts and things like that, that may be enough anti-competitive conduct to find a violation of the Sherman Act. Now, going back to the founding generation, I think, and I'm speaking in sort of broad political theory here, but you had two leading lights kind of in that generation when it came to political thinking. You had Thomas Jefferson and you had Alexander Hamilton. And there isn't a perfect analogy between those two and the two parties today. Hamilton believed that what we needed was big institutions, big government, big business, big military, strong executive power, centralized power, and that's the way we were going to become a powerful country. Jefferson was on the other side of that argument. He thought we were a lot more free if we had small concentrations of power and sort of every man is a king over his own little domain. And so when the Louisiana Purchase happened, it kind of everybody could get 160 acres was not big enough for a big slave plantation like existed in Virginia in Jefferson's time. It was big enough for a family farm. And I think Jefferson thought we were more free living that way. And the two, Jefferson and Hamilton, had competing visions of America. And as you may know, when they were both in President Washington's cabinet, they didn't get along. Now, in my view, I want to see, traditionally, Republicans have been the party of big business, small government. Democrats have typically been the party of big government, small, smaller business, less corporate power. Although that's less true in recent years.
Mm-hmm.
I think Hamilton's vision has won out over the years, but I believed even before the last election that what we needed was a Teddy Roosevelt to come in and
Jeff,
equalize that corporate power.
Jeff, are you saying to me right now, because I mean, I appreciate and thank you for, but are you saying to me that right now Trump in the last 13 days of the election is the spirit of Theodore Roosevelt?
Not necessarily. I hoped he would be. My hope was that he would be the trust buster to some degree, that he would take on entrenched interests. And I was very disappointed actually when the whole 2008 financial crash happened, that that everyone said the sky was falling and we rushed in to bail out the 8 large investment banks on Wall Street. I don't believe the sky was falling. I can talk to you about that if you want. But
right now, sorry, Adam, were you going to jump in?
Well, I was just going to say one thing. I think it's important for the audience to understand. Originalism is perfectly suited to deal with any issue involving technology, because originalism is simply about applying the provisions of the Constitution to contemporary events. It doesn't mean that originalists cannot do that. It simply means that originalists are going to interpret the Constitution and its language in the way that the drafters understood its provisions. So, for example, the Fourth Amendment in Riley versus California, the court interpreted the language of the Fourth Amendment, the reasonableness language, to hold that searches of cell phones incident to arrest were unconstitutional. And again, in Eighth Amendment jurisprudence, the court has held, based on science, that it's cruel and unusual to make certain defendants who are intellectually disabled, an IQ under 70, eligible for the death penalty. So originalism is really adaptable. What originalism is about is making sure that the justices are intellectually honest in interpreting the words in the way they were meant to be interpreted. The difference with living constitutionalists, sadly, is that they manipulate and ignore the Constitution's words to achieve predetermined outcomes that are consistent with their policy preferences. And you saw that in Griswold versus Connecticut. It's probably the best example, where the penumbras elevated from the Constitution, kind of like invisible penumbras that they just invented to create those rights.
Okay. Coming to you, please. Nick, your microphone. Anyway.
Oh, okay. All right. The mouth of the South has just arrived. Yes. You want my opinion on
because
this, right, sir?
I want everybody to commit to their positions first, so we know which way to shoot.
Okay. Well, okay. Before that, I'll give a little story about Duke University and the law school. So my son was going to Duke University PhD program in electrical engineering, not law school PhD, but he noticed that the law students were carrying around these huge amounts of books. And he said, Dad, there's only one thing bigger than the amount of books these law students are carrying. And I said, no, what is it? He said, those are the law students' egos. They're huge. Okay. And so with that, here's what we got. We have lawyers who are mathematically and technically challenged, looking at a technical subject. Now, listen to me. If you were good technically and you were good at math, you wouldn't have gone to law school. You would have gone to engineering school and make thousands of dollars right out of once you got your bachelor's degree, or millions of dollars if you could create something. Okay, but then if you go, I can't do anything really useful with my life, but I'm a good BSer. Law school's for me. And so they head to law school. I mean, that's the reality. You know that, Adam. Jeff knows that. Bill knows that. Everybody in law school, the first thing they do is, well, I'll BS my way through. And okay, so now the ones that are the better BSers, they move up to judges. So and they sit and they're going to now look at a technical issue. And I see this all the time in my actuarial practice. I go, it is weird to see a jurist look at actuarial numbers. As a matter of fact, the justices don't even want to look at actual numbers, because once they do that, their minds go, ooh, I want to figure this thing out. Okay, so now what they have to do is they got to figure out, search engine optimization, whether or not they actually manipulated that for a monopolistic standpoint. This is going to be the greatest circus in town. Listen, okay, and not only that, in the meantime, lawyers will make millions of dollars, at least on the private side. Right. So Adam, who denied being a antitrust lawyer, if he was in private practice, and I'll give you a story about one of my law partners who did that, who would jump up and go, did you know I'm really an antitrust expert? Why? Because a lot of the judicial canons say if you are licensed to practice law, you're basically competent to practice law. So all of a sudden you're an antitrust expert. And antitrust experts will be a demand for $750 to $950 an hour. Okay, seriously. And for $750, $950 an hour, it's good to look through the Sherman Antitrust Act, dust it off, and take a little look-see and see what's going on to figure out how Google can defend this unbelievably horrible monopolistic position that they have, where 90% of all searches today go through Google. Okay, so hey, it's a monopoly. Are they using their monopolistic power to destroy other companies? Come right here to North Carolina, guys. Okay, none of you are in North Carolina. Epic Games right now getting hit with a 30% commission just to put their app on the Google store. Can you believe that? Do you know any business in the world that you get 30% of everything they get because they have to come through you? Seriously. And they're right now, and there's an antitrust suit going on right now here in North Carolina against Epic Games, which is a $17.6 billion company just valued here in Cary, North Carolina. And now we have a federal antitrust suit. I love it. Okay, because the thing is, there's no question those boys in San Francisco are beating the bejeevers out. Matter of fact, I had to pay homage to them today. I can't tell you the thousands of dollars I pay Google. Why? Because there's nowhere else to go to. Why? Because they have a monopoly. Hello, wake up. Now, whether or not they get busted under the Democratic administration, I would say yes. Of course, they're going to continue because they love trust busting. Why did Trump do it? This is not right for him to do it. But guess who's shutting Trump up? Twitter, Google, shut up. And you know what? And here's the reality. They are controlling the media. Think about it. They control distribution and what you see, et cetera. So yeah, you turn the mouth of the South on, and of course you can mute me like they're going to do the president and turn me off.
No. I'm going to leave your mic on. Although I do want to, to our viewers, I want you to know the whole notion of and the idea of having a mic at the debate emanated and began and sprung out of Nick Palavida's. Yeah. We have it on tape at IBM TV, International Broadcast Media. However, I want to get back to this salient point and just kind of make two things clear. The problem with originalists and our ever-emerging society is that our norms change, our values change. We become more mature, and we look at life differently. And the way the words were written over 200 years ago is not how they would have been written today and or meant. And so the basic flaw in originalist theory is saying, on the one hand, we have to stick to the words, but then at the same time saying that the same words can now were contemplated to cover things like viewer hits and likes and dislikes and happy faces. There's just no way. Now, that having been said, Adam, because I believe a living will does in fact do that, because it's flexible and it embraces each of our new challenges and each one of the times in life when we evolved. So, however, I don't think that the Justice Department should break up Google. We've seen what happens. Well, after they did it with AT&T and after they did it with Microsoft, there was nothing but chaos in the marketplace. And there's going to be chaos. Can you imagine? 20 years of Google setting up their infrastructure and their deals, which are perfectly legal. I can make a deal with Nick and say, Nick, I'll pay you if you put my app on your phone. That's perfectly legal. That's all they've done. Now, the fact that they happen to be very, very good at it should be no reason why the government should be sticking their nose in under any kind of act. Sherman Act, Anti-Sherman Act, Boohoo Act. I mean, they're just upset that Google is successful. And I'm not sure, Jeff, that you can justify sticking your nose into Google with the Sherman Antitrust Act.
Boy, he sounds like a libertarian, Jeff. I don't know what you're going to do.
First of all, when we talk about originalism, I don't believe the Constitution, there's a direct constitutional question implicated in this antitrust suit against Google. Now, someone might argue that it's not within the enumerated, that antitrust isn't within the enumerated powers. If anybody wants to have that debate, I guess we can. It seems, though, like the broad language that that Congress has power to regulate commerce among the several states would suffice to make the antitrust laws constitutional. But that'd be an interesting topic to take up. I think where we're talking about originalism here is whether the words of the Sherman Antitrust Act can be plausibly interpreted for today in terms of the internet and the technology that we're talking about. By the way, Nick, the dean said the first day I walked into law school, you guys all think you're pretty smart, top 10%, yada, yada, yada. I know the truth. You can't do math. And it was definitely true then, and it's probably still true now.
Today, right.
Anyway, as far as how to justify taking apart Google, well, I think you've got monopoly power. The question is whether you have anti-competitive conduct, because just being a monopoly competing fairly isn't enough to bust your company up. You have to be affirmatively trying to eliminate competition.
That's right.
So that's really the question under the Sherman Antitrust Act is, whether things like mandatory default settings, apps that you aren't able to delete go away. It's kind of ironic in the complaint against Google. The plaintiffs point out that Google actually made all of these arguments against Microsoft in the Microsoft antitrust action years ago.
Yeah, I know. Adam, your thoughts?
Well, the first thing I wanted to say was, for everybody out there who has a grievance with our legal system or with public policy, that you have two options: pass a law through the legislature or amend the Constitution. Originalism is adaptable to current circumstances, certainly. But what originalists do is they make sure that they interpret the words in an honest way to reflect what the drafters understood. And what the benefit of that is that it restrains the judiciary from making choices and making them into philosopher kings who decide public policy however they subjectively see fit based on their moral values. The problem with living constitutionalists is they see the Constitution as a guide. So they find and discover in the invisible penumbras a right to privacy under the 14th Amendment that could not possibly be gleaned from the text. And regarding Google and the Sherman Antitrust Act, I think it's not as much originalism as it is textualism. And I think the difficult part is going to be showing that Google had an intent. to stifle competition. Intent is very hard to prove. You can infer it from the circumstances, but I think that's where you're going to have a problem.
Nick.
Yeah, well, see, the thing is, I agree with Adam that you shouldn't legislate from the bench. Okay, so we have the law already out there. It's the Sherman Antitrust Act. The judges are there not to legislate; they're just to enforce the law as written by the legislature, and that's it. Okay, but we do have a law. It's the Sherman Antitrust Act, and of course, it will be up to them to interpret the law, which is going to be very interesting to whether or not monopolistic conduct took place. In other words, like I agree with Jeff said, you can be a monopoly, no problem, but did you use this in such a manner to stifle competition? And that takes a lot of discovery, which means you're going to see they're going to be poking around. And that's what they did. They poked around Bill Gates' office. That's how they got Microsoft when he said, "We're going to crush the competition." In an email.
No, Nick,
okay, no, that's not a good thing to put in an email.
No, Nick. I actually need you to be very, very clear for our audience, because that's actually true, that they literally went in and they found this stuff. And Nick, what did they do? They found it in what, an email?
Yeah, it was an email. But I mean, the thing is, if you look at it from Bill Gates' position, that's what he's designed to do, is to build up the assets of Microsoft and crush the competition. That's what you're in business for, is to build your company up and destroy any of the competition. Unfortunately, if you're really good at it, like he is, then you turn into this monopolistic monster, and the antitrust guns are pointed at you. Right now, they're pointed in, where is it? They're pointed in Mountain View or wherever Google's headquarters are, and they're aim, ready, aim, fire, and they probably have a good case. The DOJ. Now, how did it get there? Okay, it could have got there because of Oracle. Donald Trump's great relationship with Oracle and his bad relationship with Google. And he may be sending a message to Twitter and some of these other monopolies that are out there. You keep playing games like Twitter and shutting me off because you can do so. You're powerful enough to do so. And by the way, Google hit us. I don't know that on IBM TV. They whacked us through their YouTube thing. And
yes.
Yeah. And Bill, we don't. They're judge, jury, and executioners at YouTube. Okay, absolutely. Okay, and the thing is, let me tell you something. When the sharks attack, the other sharks start swimming out there. So YouTube boys, you listen to me. You come after IBM TV, you may find a little sharks floating around your alley, but they came after us, didn't they, Bill?
Yeah. Yes, they did.
And did we have a right to respond in court?
No, we didn't. Actually,
were they judge, jury, and execution?
Yes. Yes.
Thank you, sir. Is that a monopoly using monopolistic practices?
Yeah.
Okay. See the problem they have, and we have it right here at IBM TV. Let me tell you something. Google's in a world of hurt, baby. World of hurt, baby, and they're going to get it right between the eyes.
Well. Then look. I just want to tease this out, and I want to hear from Adam.
Did YouTube take us off the air just then?
No, I don't. Find out tomorrow.
Well, no. What they're doing. I don't know if you guys know this, Adam.
Actually,
they're going back and looking at all of our tapes right now. I'm serious. Either their bots or their eyeballs.
With bots.
With bots. Yeah.
So, And they think it's a game of baseball. They give you 3 strikes. And so we have these anonymous bots combing through all these millions of terabytes. And if they find one thing that they don't like, they issue summary death.
That's right.
They just kill an entire network. It's crazy. But Nick, we're here, and I want to pick their brains on this. Now, if the government was to break up Alphabet City, what happens to Google? How do you take Google apart? Do you sell the search engine, Google search?
Wait. Let's stop right there. Okay, their search engine, as you know, is owned by their Irish company to escape taxes. Everybody knows, especially Professor Sleinbald, who is a professor at USC, where you went to school, Adam. He teaches at the graduate tax program. Google engaged in here we go. We got Beckett Cantley coming in from Northeastern. Let's get him. He knows about this. There he is, Beckett Cantley. Knows about this. We're talking about the Google antitrust suit. Everybody in tax law knows that Google sold their search engine to their Irish company, leases it back through the double Dutch Irish sandwich, so they have to pay taxes in the United States. Okay.
Yeah.
Is that true, Beckett?
Apple's the same way.
Apple's the same way. Okay. All the guys listening, all you poor, what do they call it, suckers and losers that work for a living, realize that Google Apple, Microsoft, I'm not sure about Facebook. They all sold their assets overseas to Ireland and then lease it back so they don't have to pay taxes here in the United States. You tell them, Beckett. Tell them what they did.
Well, yeah, Apple's even weirder because they have a state grandfather provision that was carved out for them back in the 70s. So they don't pay anything. I mean, like nothing.
Yeah.
Okay, but fine. But I mean, Professor Beckett, doesn't the Sherman antitrust law still apply to them, even though they are?
I'm all for the antitrust action. I mean, I'm sorry. This is one where, I mean, I don't think they necessarily hit Google where they should have, because I don't know that the search engine, that people, I do believe that people can choose their search engine, and they know there's a number of them. Google's just better, right? But what they do is they manipulate the hell out of the results. And where I have an issue is that they're creating content by managing content. You see what I mean? And so the real issue out there is that they have no liability for the content on their search engines, and which they're managing. I mean, they're literally picking who can see what in a meaningful way. And so if there's damage that happens because of that, they shouldn't have an exemption from it, and they currently do.
Okay,
so that's a little different than the antitrust action, but I'm saying, the monopoly issue is the same.
Right. Yeah, and their motto was "Do no evil that anyone can see." Okay. So the thing is, wait, did I add that last line?
Yeah, you did. And I think
sorry about that.
I think you poked the den. First, I want to ask Professor Adam. Now, is the resulting damage enough? If evidence of the damage that Professor Beckett talks about, is that enough to then turn around and infer intent by the results?
I don't know. That's going to be a very complex question, because it really implicates the issue of, I mean, businesses by their nature, broadly speaking, are supposed to be anti-competitive. They're supposed to defeat their competition. I mean, that's what businesses do. So the question is, at what point does your tactics in seeking to become a monopoly or monopoly-like violate the act? And I think it's very difficult to draw that line and to create a workable standard by which that's done. Because, again, the goal of a business is to maximize its profit and to shut out other competition. And it's done all the time. So tell me where the line is between permissible conduct and conduct that's not permissible. And that's where I think the judges or the courts are going to struggle.
Okay, so Jeff, where do you think the line is between that Google may have stepped over? Because clearly Professor Bennett thinks so. In many ways, the manipulation of the content, which creates content, and also by the same token, many people complain about the loss of our privacy. So they say that because they're monopolistic, that if they were broken up, other companies could come in and offer better deals for individuals so that they could protect their privacy and their data. But Jeff, where is the line that, one extra dollar is too much and you get thrown in jail for antitrust?
Well, the Sherman Antitrust Act, as you may or may not know, is very broad language. Any agreement or combination of restraint of trade, something like that. Of course, every agreement you have is in restraint of trade in some way, but the courts since then have defined it to take those two elements I mentioned before, monopoly power and anti-competitive conduct. Now, are these agreements that Google is allegedly entering into these exclusionary agreements? Is that anti-competitive conduct? I strongly suspect that the DOJ has a good case there. As Nick said, though, it's going to be super hard and expensive and time intensive to prove it. I recently filed a subpoena on Amazon on behalf of a client of mine, and I have to be careful not to disclose anything confidential, but I can tell you, in a conference with an Amazon litigation attorney, she told me, well, we've got all of these requests that are very broad. Tell me anything you know regarding this person or that person. And she said, you might think that because we're Amazon and we're a tech company, that we just can hit a few computer keys and have all this stuff at our fingertips. And she said, Amazon has a mammoth amount of information, but it isn't designed to get at it in discovery. So, trying to narrowly tailor discovery requests to this behemoth mountain of data and to get what is actually being requested without omitting anything is not going to be as easy as people think. It's going to be super, super difficult. And Google is going to fight it every step of the way. So it's going to cost a lot of money on all sides if they take it all the way.
All right. Well, Beckett, how would you break up? And I'll just call it Ma Google. In honor of Ma Bell. How would you break up Google? Oh, we can't hear you. Hang on. Okay.
I'm sorry. I'm in the car, so while someone else is talking, I was trying to keep it muted. Okay. In any event, I don't know where to draw. They seem to be commentators seem to be looking at the difference between the search engine side and the monetization on the other side of advertising, but I don't see how that works. I mean, they seem to be completely hand in glove. So I don't know. I really don't know. I was going to ask you, Bill, in Washington. Google and the other tech companies seem to have a very friendly ear in the Democratic Party. And hence they're playing favorites in the manipulation of political information. And I was wondering if Biden takes over, will this thing continue?
Okay. Well, first of all, I can say yes, but as we know with lawyers, it's just called forum shopping. They're just looking for the best deal with their lobbyists. Now, we as attorneys always forum shop. Where do we file the suit? Do we like this judge? Do we like that judge? Well, maybe not for the professors. I'm sorry, not for the LLMs in the group here, but other people. We do try to maximize what little advantage we have, and that's just called forum shopping. So, in the same vein, yes, you're absolutely correct. The tech companies do have a friendly voice in Washington. Generally, it's with the Democrats. But that is too broad a statement, because in the Democratic Party, you've got two distinct forces. You've got the progressive wing of the Democratic Party, and then you've got the more moderate ones. And the more moderate ones have been cozying up to the tech companies, obviously for support, for money, and because of the potential jobs. I mean, the minute Amazon says that they're going to build a warehouse, a distribution warehouse in an area, the politicians are all over it, so they can declare, we've got jobs. Now, where you have a problem is that on the progressive wing of the Democratic Party, you've got people like Senator Elizabeth Warren, who, believe it or not, is lockstep in line with what Bill Barr is doing with this antitrust suit against Google. So, I mean, it's really kind of interesting. So I would say, yes, they are forum shopping in terms of the Democrats. And yes, right now, the Republicans are mad because they have this perception that they're censoring them. And maybe they are, maybe they aren't. I mean, that's an entirely different area because it gets into the subjects. But assuming they are, Republicans are mad at them. Middle of the road Democrats like it because of the jobs and because of the power and the influence and the communication. The left wing Democrats don't, because they.
I saw Jerry Nadler today. Support gives you from the progressive side, right? But the where do you think Biden sits? He's traditionally been more of a moderate, Democrat, but he seems to have saddled up pretty closely with the progressive wing for the election. What do you think?
You actually ask a very important question, and this is what I will suggest. Well, I think it's clear to me. Most people are not going. Well, they're not going to publicly say so now because we are before the election, and that is this: that the Biden, in order for a potential Biden presidency to begin to take on the way they're looking at our current crises right now, he is going to have to be a very activist president, somewhere along the mold of FDR. And on that scale, in order to attack the various issues. And the way I think that they are forming their cabinet to do it. And you're right, Becca, there is going to be a greater influence of the progressives in this regard. And that means that the progressive wing of the Democratic Party is going to have a seat at the table. I was reviewing some information today and stories and talking to some people. And, while the public is focused in on the polls and everything right now, there's always this thing called the inside game. And that's the transition game. Both candidates have set up their transition offices in case, depending on who wins. Now, the Biden administration has already set up their transition office, and by the way, the American taxpayers pay for it. But what they do, and this is really where you begin to see what the ultimate administration is going to do, it's who they're interviewing, who they're talking about key roles. That's over at the Treasury, that's at Commerce, that's at the Department of Justice. And they're talking, and traditionally it has been with both parties on the economic fronts, that is Treasury or the Federal Reserve, they brought in bankers from Wall Street so that things have substantially remained consistent with fudging around the edge. But this time they are actually talking about leading progressives who are leaders and qualified in all other respects coming in. So to answer your question, I think the Biden administration is not saying anything about it right now, but I think that they are looking at very expansionary kind of aggressive pursuit, because the progressives will have a substantial influence. And I don't necessarily suggest that, it's tough for me because, look, I like my Republican friends. I think they're sensible. I tend to be sensible. And, and I cringe at times when the left is way out too front, leaning over their skis, some might say. Nick, that was for you and your one.
Yeah, but what are you guys doing talking about left and right? See, this is what gets me. Okay, being a businessman. Okay, when we hire people, the first thing you do ask them in your job interview, are you a Republican or a Democrat? Are you a conservative or a liberal? No one asks that. Come on, Bill. No one asked that question.
Nick,
you want to know whether or not they're doing the job. Now, when it comes to the antitrust suit, I don't give a rat's rear, except it's moi. When YouTube, which is a subsidiary of Google, Google owns YouTube and YouTube TV and YouTube Media and who knows what else, comes to IBM TV, and Beckett doesn't even know this, and gives us a 3 strikes, you're out. We're the judge, we're the jury, we're the executioner. You have no appeal. We're going to shut down IBM TV. You tell me, Bill, that isn't a monopoly coming after poor little old IBM TV crush. And we're not supposed to retaliate? Of course we retaliate. Yeah, break them up. Don't lock them up. Break them up. That's what I say. And break them up, because the thing is, they're using their bully weapon on poor little old IBM TV. You saw that firsthand, Bill. Okay, and that's a business deal. That has nothing to do with what Adam does, whether he's originalist or not. Who gives a rat's rear when they shut your company down? That means something to me. I don't really.
Everybody loves originalists.
Well, I mean, you can love or hate originalists, but man, when you're a businessman, you're looking at, hey, they're hitting my dollar bill pocketbook.
Okay, listen. Let me ask you, Adam, then, because I think on one of our previous shows, with your your valued contributions, you indicated that your view of soon-to-be Justice Barrett was that she would consider the practical impact of the potential rulings, and that she, like you, was an originalist. So I ask you, Adam, are you considering the practical impact, things of which, like Nick is talking about the sword of Damocles coming down on poor little IBM television, when all we try to do is at least give a job to the just dollars out there, and and make us feel better.
Exercise our First Amendment right, and they're going to shut us down on strike 3. No appeal, no nothing. They don't like what we did, and so they're going to whack us up, and there's no appeal. They just
what they do is
just shut you down.
Nick, I got it. You're angry right now. We're going to go to somebody that is learned in
yeah, which means stay away from me.
Yeah.
That's a good idea, Bill.
Adam, under your school of thought, would you take into account the practical impact and the damage that Google and Alphabet City is doing?
Absolutely. And I think it's not inconsistent with originalism. Originalism at its core is about the process of judicial decision making. It is designed to ensure that judges interpret the Constitution in a manner that is intellectually honest and consistent with the understandings of the drafters. So it ensures the integrity of the decision-making process, which in turn inspires public confidence in the justice as arbiters of the law, and it also preserves the rule of law. But that doesn't mean you don't consider the practical consequences. You have to consider those consequences and the values that they may promote, such as, do they promote democratic values? Do they enhance participation in democracy? Do they promote competition? And you can certainly continue to consider the practicalities, but you have to do so in a way that allows you to interpret the Constitution in an intellectually honest manner. So you can do both, and I suspect that Barrett will do both, and I suspect she will become the next Justice John Paul Stevens.
Okay, I'm going to get to Jeff. Jeff, I'm giving you a warning because I'm coming to you next. However, Adam, isn't that the very definition of an activist judge, something that you absolutely abhor? Because if they're taking into consideration the practical implications, aren't they just sitting there making value judgments? And aren't the value judgments about the policies of the law really reserved for the legislature?
No, for two reasons. The first reason is if they're considering the practicalities but basing their decision on a reasonable interpretation of the Constitution, a legitimate interpretation that's consistent with what the founders understood those words to mean, then there's no problem with considering the practicalities. The second reason is there are circumstances where the Constitution is admittedly ambiguous, such as the Eighth Amendment. What's cruel and unusual punishment? So in that context, you can still responsibly stay faithful to what the drafters decided regarding the purpose of the Eighth Amendment and the words, but also consider the effect, the outcome. And that's why I think a case like Hall versus Florida, where the court decided 5-4 that it was unconstitutional under the Eighth Amendment to execute somebody with an IQ under 70, you can argue that was perfectly originalist. Originalist isn't so rigid, but what I think it requires is staying faithful to what the drafters meant, just like as you interpret any statute. You don't make up what you think.
Okay. Listen, I appreciate that, Adam, but we're going to move on to Jeff. And I just want to say, Adam, as my final best defense to just the intellectual assault I just suffered, living Constitution is a better name. Jeff, can we?
Ouch.
Do you, in your school of thought, do you take into account the impact of the damage, the items that Professor Beckett talked about, the damage that's being done when you interpret the law?
First, is the Sherman Antitrust Act unconstitutional? That part of the analysis, I don't know that anybody's challenging it at this point. If somebody does make that argument in the litigation, we ought to have a show on that. But assuming, for the sake of discussion, that it is constitutional, then the originalism that I'm adopting is the original intent behind the Sherman Antitrust Act. And is there a combination or agreement in restraint of trade? And so I think then we're looking at, does that require us to take into account the impact of the decision that a court might make in the matter? Now, I think when we look at at least how the act has been interpreted through the years, you have to look at not only whether they have monopoly power, but whether they're using that monopoly power for anti-competitive conduct. I think that probably anticipates taking into consideration the impact of what they're doing and whether they have the power to do what they want to do, to behave in an anti-competitive way. Now, Nick talked about what if they're going to squash IBM TV? That's an interesting idea. I hadn't thought about. IBM TV is showing up through YouTube. Is IBM TV a competitor of YouTube? It's certainly not giving, YouTube certainly isn't giving IBM TV any, semblance of due process. The question I guess I have is, are they doing something anti-competitive to shut you down, or are they just being stupid? I've had the same argument with Amazon. I mean, they will shut you down if they'll shut down your Amazon store if you, if you file a lawsuit against another Amazon seller. And yet there's only a small, very narrow number of things that they will accept a complaint about. And I mean, literally, one bad review by a customer on your Amazon store can get you shut down. So, I mean, there's all kind. I think that really we're probably going to need some kind of legislative fix for all of these very large tech companies that maybe treat customers or sellers unfairly. Because I don't know if the Sherman Act answers any of those questions.
Okay, Nick.
Mhm.
What I've been able to glean from our panel is that we are solidly in this notion of break them up. Now, Adam will get there because of the impact. Method is just mad. I mean, rightfully so, across the board. Nick, you're still licking your wounds from today. But this is the question. Nick, how would you break them up?
Well, by the way, Bill, was that today or yesterday that YouTube was going to shut us down?
That, you
I think it
know,
was yesterday because Gwen had to take those tests.
yeah, actually, it was
Right.
yesterday.
Right.
Well, actually,
Anyway, we had to go into defense mode on YouTube. But see, here's one of the problems, and I mentioned it when we were working with IBM. We had a 2-year contract with IBM, and I said, look, you guys have no media play. I said, if you look at every other tech company, they're buying media. Why? Because they buy the power of the press. I mean, and Hitler even figured it out. He had this guy Goebbels. He goes, we're going to control their minds through the press. I mean, come on. And so if you look at it, look at who's bought television. Apple now has Apple Plus television. Go look at it. Google has YouTube, which turned into YouTube TV.
Mm-hmm.
Go look at that. As you go through every one of them, Amazon has Amazon Prime. Okay, every one of the tech companies have gone in and purchased media. Oracle is about to buy TikTok, and IBM, and I talked to some of the top executives at IBM. I said, guys at IBM, you have nothing. Okay, you're like asleep at the wheel. And so the thing is, and we're not owned by IBM, by the way. But the thing is, and maybe we never will be, because the thing is, should a high-powered tech company own media? Because see, what happens is now they have a huge monopolistic position, not just on the search engine, Bill, but also on television with YouTube TV and also with YouTube generally itself. They control the hearts and minds of a lot of people.
I know, but I mean, that's an argument for breaking all of them up.
Yeah, absolutely. Break them up.
Okay, well,
every bloody one of those boys in San
Francisco. You know what you ought to do? You should have joined Elizabeth Warren's campaign. I literally cannot.
I'm not a fan of Elizabeth Warren, but she's right on this.
This is why they call it the lawyer's den, because only lawyers can make black white.
Where's my hammer? There we go. That's a gavel. That needs to be turned into a hammer, and you need to break up these tech companies. Oh my lord!
No, but seriously, if Adam and Jeff, found that the Sherman antitrust law was in fact violated. Beckett, Nick, how would you guys break up Google? How would you disentangle the entire? Because it doesn't even look like you can do it, because Beckett didn't that they're handling.
I know that it would be great to have them in smaller pieces for the reasons you guys were talking about earlier, where we might have some competition, but I have no idea.
Well, number one, force them to divest YouTube. In other words, step number one, they cannot own YouTube. Force them to divest that, spin off YouTube. You notice IBM actually did divest themselves of their service department recently. Right. They have no business owning YouTube. To force them to divest it, that's step number one. Step number two, stop this where you can transfer your search engine offshore. And most Americans don't even know they did that and lease it back so they have to pay U.S. taxes. So what they did is, and Beckett, you know it. Okay, yeah. I know that, but we teach it graduate tax. The rest of the people don't know that.
Yeah, so that's a little different than the antitrust question.
I know it's an antitrust, but it just shows the intent of what these tech companies are all about. They're not about helping the American public. They're helping the people in Mountain View, California. If you're in San Francisco, that's the reason these little shabby homes go for millions of dollars, is because they're sucking the money dry of the people around the world, and including people here in tiny little North Carolina. So yeah, you need to break these buddies up.
Okay, but you see, Nick, you at that point just raises just the whole web of this issue, because then, in order to begin to divest or break them up, you then have to attack the tax laws and what they were doing. And so, when you pull one string, you're pulling on that string, and you don't know what's going to unravel. Perhaps the edges of the Constitution, Nick.
Well, then you go to Adam, and he'll be an originalist. He'll leave us alone. So I think that's okay. You know? So
You're welcome.
But in the meantime, the thing is, the whole theory of the Sherman Antitrust Act bill is that we had concentration of power. Back then it was with the oil and the railroad industry in a very small amount of people. Do you know, and we did a study on this, on venture capital, 40% of all venture capital comes from Silicon Valley. In North Carolina, where we live, it's 0.075. That's it. You know, all the capital is there, buddy. So if you want your life controlled by those commie hippo pinko freaks, excuse me, the people in San Francisco, okay, then you can do that, and you can suck up to your Google masters and your Apple masters and your Oracle. But there's some people that don't want that, you know? And so the thing is, we need to bust these boys up.
Okay. All right. Fine. Then I'd like to do this. I'd like to call a kind of a timeout, and I just want to go around and I want to hear from each of our guests how, well, what their thoughts are, because we're coming to the close. But I want it to be meaningful. I know we crack a lot of jokes here. Actually, Nick has a lot of bad jokes. I just take cheap shots. But you, gentlemen, anchors of our program, and the viewers come to rely on your wisdom and judgment. So, Jeff, we'll start with you. You have closing thoughts. We'll go to Adam and Professor Beckett. You get Nick will always take the final word. But Jeff, how are you? What do you got? Hang on.
To be suspicious of concentrations of power, either public or private, and I want to see the big tech companies decentralized. So it doesn't hurt my feelings that Google's being hit with an antitrust suit. It could make a mess. There's no doubt about that, but it might be healthy in the long run.
Okay, Adam.
I think that you have to show that there is an anti-competitive intent, and I think that's going to be difficult because, again, the purpose of a business is to destroy and defeat their competition. So where do you draw the line between what's permissible as competition and what's impermissibly anti-competitive? And I just don't really honestly have that much of a problem with the way things are right now. I think it would be a nightmare. The litigation is going to be a nightmare. Breaking up Google would be a nightmare. I think Google's fantastic. And I think in some instances, monopolies aren't necessarily a horrible thing. I'll put that out there, and I'll just leave it there.
Oh my God. Dr. Marcus, every single time Adam surprises me, because by the end of the show, him and I are on the same side. We're like, leave Google alone. Professor, I can't believe it.
Agreed.
Yeah, I don't see it that way. I'm with Nick. I'd like to see them broken up. I think there's an enormous host of activities they've gotten themselves involved in that are harmful to the American legal system and the American structure, just how our social system. And I'd really like to see. I love the idea that you're telling me that we're going to have people that are more progressive minded when it comes to this particular issue coming into the Biden administration, because then you may have a continuation and even may a better chance of having them broken up. And I applaud Republicans and progressives who can work together to do that.
You're absolutely right on that point. And I think the Democrats are running around and silently just whispering amongst themselves. But once, if, and when they win and control all three branches, you're going to see a brand new fired up Democrats. Nick?
Yeah, so I agree with Professor Cantley. Of course, we concur on this one, and we have the majority opinion, or at least we'll write the majority opinion, because we'll get Adam to sustain or concur somewhere along the line. We'll talk about it.
No, you have you, Jeff, and Beckett.
There we go. Because the thing is, Bill, you've experienced it firsthand already. Yeah. The extreme power of Menlo Park is hitting us here home. And see, the thing is, I don't mind them being a monopoly. I agree with Jeff. Okay, but when they come after our First Amendment rights, which is what they're doing over in Menlo Park, you need to bust these boys up. And we have hard proof evidence that they're doing it to our friends at IBM TV. Happens to be our network. So with that, that's all I have to say.
Okay. Well, normally you would take over this role, but I guess I will.
Well, that's because it's 8 o'clock.
I know it's 8 o'clock, and I'm trying to wrap it all up. I thought that I would rely on your eloquence, but apparently you're out of words today, Nick.
That's because it's 8 o'clock and we have to go.
Okay. Well, listen, to our audience, thank you. Our panelists, Jeff, young man from Utah, go west, young man. Adam from Georgia, mouth of the South. Even though Nick is the grand fromage here, we also have Beckett, who, just like the post office, through rain, storm, sleet, and snow, he's in his car, but he's here with us to make sure that we get it right. And so for that young man, we thank you. I'm Bill Trudon, and this has been IBM TV, the Lawyer's Den.